Okay. Thank you, everyone. We'll just, in the interest of time, we'll get started. So today's panel is going to. This very. Normally, I'm very short, but this is actually. Okay. So today's panel is going to. Well, not panel actually. Roundtable is going to have a bit more of a conversational tone, because it's a discussion among folks who've had an engagement with a specific type of project. And the way we'll proceed is first we're going to have, I'm going to give you a very brief overview of what that project was really about, but it has already been alluded to by some of our colleagues. It's the effort to develop a set of principles and guidelines on human rights and public health emergencies, which was a 3-year effort, which was led by many of the folks who are in this room today, but also lots who aren't with us. And so we'll screen a documentary about that process and follow it by having not a full-length feature film, by the way. We're going to have a 10-minute mini documentary followed by sort of a discussion, a conversation among those who were engaged in that process. Some of us are on stage today, others are in the audience. So I also encourage Ali, Lisa, and Ben to chime in and contribute as you wish, and all of you in the room as well. So what is this project about? We have talked a lot today about global health law and human rights. And so that's really the wheelhouse of my work. That's where my personal research is situated in. But it really took that area, if you will, of that body of knowledge, that area of research really took flight with a lot of people becoming interested in the work through COVID-19, and because of the very vast human rights implications that COVID-19 posed to everyone. And it wasn't a new thing for those who have been engaged in this work for a very long time, including Professor El Yemen, Professor Foreman, Professor Meyer, many who have been engaged in this work for a very long time knew very well that health and human rights are inextricably linked. So these were not what we saw in COVID, and I think my students as well have discussed this with me. Even they know that none of the consequences that came out of COVID were sort of foregone conclusions. We could have done much better because we had experience to draw from. And the thing about COVID that really merged communities together was the fact that the international human rights law community hadn't really extensively thought about what a global pandemic of the scale and of the intensity of COVID, what that might require in terms of human rights obligations, not just during the response, but well before it, as a prevention measure and as a preparedness measure. And in turn, the global health law community, so the community of folks who deal primarily with the World Health Organization and its very few legally binding instruments that it has, they hadn't thought about what human rights considerations actually improve the public health response to a public health emergency. So there was a disconnect between communities of practice, if you will. And when we came together as the Global Health Law Consortium to develop an interpretation of the international health regulations back in 2019, one of the things we remarked was how little the international health regulations, which is this legally binding treaty that's supposed to govern country responses to public health emergencies of international concern, how little that treaty, that agreement engaged with human rights. We have folks in the room who have written extensively about this disconnect between the international health regulations and for instance, the right to health under the UN human rights system. So all of this was boiling up into a sort of collective awakening or reckoning, if you will, of what we need to actually do to bring these fields closer together. And part of that was a rapprochement through engaging with bringing global health law scholars to engage with human rights scholars to develop a set of principles and guidelines on human rights and public health emergencies. That work was rendered possible because of a collaboration between the Global Health Law Consortium, which is a group of researchers who work in global health law, and the International Commission of Jurists, which is a long-standing, many of you may know about the International Commission of Jurists, but since the 1950s, at least, they've been advocating for the rule of law and human rights around the world. And so that collaboration enabled a 3-year project to develop these principles. There's a set of principles that aim to consolidate and clarify legally binding obligations of human rights in times of public health emergencies. And they also seek to promote the progressive development of norms in this area. So I will let the documentary speak for itself. So I'll ask our colleagues at the tech to screen it. Thank you.
I'm on the Syracuse Principles. In 1984, when the ICJ was working for the first time on the Syracuse Principles, the challenge really to the human rights framework was states of emergencies that we'd seen in the 1970s and 1980s. These basic principles that government responses to any crisis have to be necessary, they have to be proportional, they have to be lawful, non-discriminatory, and restricted in time and space. These concepts have now been incorporated into customary international law. One area where state responses to crises has not been properly developed has been responses to public health emergencies. And the COVID-19 crisis put that front and center.
The fear and what it was like early on with hospitals overwhelmed, morgues, bodies being burned in different parts of the world.
States had immense power. Almost overnight, the states could arbitrarily decide that people stayed in, and they, as the executive part of governments, could make determinations which ordinarily they couldn't make.
The fallback for most governments and for ours as well was public order. The Public Order Act, the public order regulations, which resulted in policing the pandemic.
But even within countries, what we saw is that it was the poor, the disadvantaged, the marginalized who suffered disproportionately. People whose rights were already not being respected were most at risk of suffering from COVID.
The world that COVID struck was one of profound socioeconomic inequality, where we had dramatically underfunded health systems, where we had capitulated greatly to private transnational interests, including pharmaceutical monopolies. And there was a gross imbalance in the global order between the North and the South.
I think human rights have been one of the victims. People have lost jobs, children out of school. So that I think has been a collective failure, frankly, in protecting human rights at the times of crisis.
COVID-19 came to us in a way that we were never prepared in terms of human rights standards. Yeah, we were not prepared to apply human rights in public health emergencies the way we've seen today, not in such large scales. So in terms of precedents and legal reasoning, it's guidance for what to do. It caught many states off guard.
Very quickly, global health law was, the IHR of 2005 was somewhat marginalized. International human rights law was also marginalized, where states didn't notify derogations, where limitations were done without legal sanction, without the rule of law. And other actions were done that were wildly inconsistent with even kind of basic, well-enshrined principles in human rights.
International law failed us spectacularly during the COVID-19 pandemic. I'll take one example, being that of access to vaccines. You had a proposal by India and South Africa to allow for greater access to things like testing, to vaccines, to treatment. And instead of responding in sort of a timely fashion and a substantive fashion to address that demand, international institutions instead stalled in terms of making a decision. And then when they finally made a decision, that decision was wholly inadequate in terms of responding to the need.
Although governments had thought about how they might respond and how human rights might require them to respond in the context of other emergencies, very little thought had been put into thinking about them in the context of public health emergencies. And on the other side, public health experts and global health experts hadn't really thought about the practical day-to-day business of governing during a pandemic. And so we all really were having to work out how to deal with this and change the tire while the car was still moving.
What the ICJ and the Global Health Law Consortium are trying to do now is to address the gap that we've seen in terms of state responses by ensuring that responses to public health emergencies comply with human rights law. And in fact, to go a little bit further, to ensure that states understand that a human rights compliant response is the best type of response to public health and improves the response to the public health emergency.
The Global Health Law Consortium is honored to work with the International Commission of Jurists, bringing together experts throughout the world in global health law and human rights law to help to craft human rights principles and guidelines for public health emergencies.
The principles we're proposing are much more comprehensive than the Syracuse's because they provide a full range of human rights obligations that the Syracuse principles don't, especially in relation to economic and social rights. Yeah, they see human rights obligations involving positive measures, steps. Yeah, whereas the Syracuse principles are looking in preventing damage and containing rights or justifications for containing rights. We are giving justifications for rights realization in the worst scenario.
The justification of these principles already exists in human rights law. So these are obligations that states have already signed up to. In many cases, these are things that states are already doing. But what we are doing in terms of these principles is to get some of those obligations and really think about how they would apply in public health emergencies.
One of the most unique things with these principles is that we had a very interdisciplinary and we brought in approach to understanding what's a human rights-based policy or what is a human rights-based approach to public health.
Is just the simple brain power and passion in the room, which I really am loving to see. Everyone really cares about health. Everyone really cares about human rights.
So as Kellen, we work with communities, particularly communities that are vulnerable and marginalized. And this process has been useful for us in not just articulating the lived realities, but being able to appreciate that the normative framework can be moved and understood within their lens and their context.
I think the process that we're going through now is exciting in that people from a number of different perspectives are precisely doing that, are reflecting on the lessons that we've learned in COVID-19, but also previous work in Ebola, for example, and thinking through what are the gaps in international law, looking both at global health law, but primarily at international human rights law, and trying to thoughtfully fill those gaps in ways that would be useful to government policymakers.
The idea is that if governments do have some kind of document, some kind of good standards that briefly tell them, well, these are the things that you should think about from a human rights perspective, very practically, when the next health emergency hits, then they're more likely to actually consider those.
We're not only building on existing rights, but we are thinking about how rights might look like in the future. And I think that this is really super important because rights evolve. They don't remain the same.
The major achievement of the principles is that there's a broad enough consensus amongst a large range and variety of experts that there needs to be forward movement in the development of international law when it comes to human rights in public health emergencies.
This is our one shot. It'll never come again for us to really transform global health governance and human rights.
Human rights are almost always the first thing to go during a crisis. But actually what we see again and again is that they should be the thing that stays because they enable communities to have trust in governments. They enable communities to seek health services in ways that are not discriminatory. They enable a wide cross-section of people to think about the ways in which diseases spread. So if we put human rights at the center of our responses to health crisis, we will be successful with the next crisis. And so these principles are really important for states as they think about the next crisis.
And if we can take that forward, and if we achieve pushing this discussion, and by the next global pandemic, which will occur, having a better place and states being in a better position to respond, then that will be a significant contribution.
Working? Yeah. Thank you. Okay. So we've talked a lot about the Syracuse principles in that video, and I think for most friends in the room, you can probably piece together some of the ways through which the Syracuse principles were both important, but were also inadequate or insufficient in responding to the public health crisis of COVID. But I thought that it would be useful for you to also contextualize things a little bit more, to have a little bit more of an understanding of where the Syracuse principles came from, and sort of exactly the areas in which they were inadequate. So the Syracuse principles were the output of a 4-day meeting in Syracuse, Italy in 1984 between a group of international law scholars, practitioners, and jurists from around the world, most of whom were, of course, men at the time, and most of whom were based in institutions in the global northern western institutions. They sought to clarify the conditions under which states were permitted to limit or derogate from their human rights obligations during national states of emergencies, broadly speaking. So they did not have a specific focus on public health emergencies in particular. They also sought to specifically examine the human rights the derogation provisions in the limitation derogation provisions in the International Covenant on Civil and Political Rights. So in that sense, they didn't examine sort of how one limits or derogates from rights that are from for instance, the economic, the social, the cultural wing of the international human rights system that we've heard about so much today, that which includes, of course, the right to health. Nevertheless, despite the fact that they were an informal consensus building process that was led almost entirely outside of the confines of formal governance institutions, the Syracuse principles have now had a profound impact on the development of law at both a domestic and international level. They've influenced the jurisprudence of UN treaty bodies. They've been cited in factum submitted even before our own court, the Supreme Court of Canada. They have been cited by negotiators as they've been trying to propose revisions to the international health regulations. So what I'm saying is, even though the Syracuse principles are not legally binding treaty, they are nevertheless regarded as authoritative enough to be cited as motivation for law reform efforts around the world. And that was a powerful realization for our group, the Global Health Law Consortium and the International Commission of Jurists, when at the beginning of the pandemic, we realized that there are these gaps, these blind spots within the Syracuse principles. That is what set us about developing the principles and guidelines on human rights and public health emergencies. Unfortunately, we didn't feel it appropriate to call it the Geneva Principles because of the fact that Geneva is not necessarily a place that one would regard as being representative of the rest of the world. But we do feel that these principles and guidelines on human rights and public health emergencies should just be called that and be descriptive. And so with that, I'm going to help us unpack or discuss the process of developing the principles. I'm delighted to be joined here by Professor Errol Mendez, who will facilitate this roundtable discussion for us. Professor Mendez is a lawyer, author, professor, and has been an advisor to governments, corporations, civil society groups, and the United Nations. He has acted on the Human Rights Tribunal boards of inquiry. He has acted as an adjudicator on those boards in Canada under the Ontario Human Rights Code, as a member of the Canadian Human Rights Tribunal. In 2005-2006, Professor Mendez served as senior advisor in the Privy Council Office of the Government of Canada. He also served as a visiting professional at the International Criminal Court in 2009 and was appointed as a visiting fellow at Harvard Law School in 2013 and a visiting scholar at Oxford University in 2020 to 2021. His areas of expertise include private law, public sector governance law and policy, international business and trade law, public international law, constitutional law, and human rights law. He has taught in these areas at law schools across Canada, and is presently a full professor of law at the University of Ottawa in where we are today. He was a commissioner on the Ontario Human Rights Commission from 2009 to 2019 and national president of the International Commission of Jurists, Canadian section since 2014. And for this reason, I'm exceptionally delighted that he's the one leading our conversation today, both with our colleague in the International Commission of Jurists in Geneva, and we have a colleague from International Commission of Jurists in Canada. So Professor Mendez, over to you. Thank you.
Thank you. Thank you very much. My first and delightful job is to give Rujan's bio. So I'm going to do exactly what she did and just try and show what an amazing colleague she is. And I'm so happy that we managed to grab her at the University of Ottawa's law school. She's now an assistant professor at the law faculty, the common law section. She is a Pierre Elliott Trudeau Foundation scholar and a senior visiting fellow at the United Nations University. Her research bridges international law, health law, and human rights with a focus on the interpretation and change to global health law. In 2022, she was appointed to the WHO Expert Committee, mandated to provide governments with technical advice on over 300 proposed amendments to the international health regulations. Currently, she was the principal investigator of a 3-year initiative between the Global Health Consortium and the International Commission of Jurists, which you've heard all about, to develop that consensus-based principles and guidelines on human rights and public health emergencies. That was launched in Geneva in May 2023 and is now the focus of our roundtable today on making the future of these principles. With that, Rujan, perhaps to give people in the room who haven't sort of covered the entire scope of the principles, can you go through what are the main parts? Because in addition to what's on the video, it is so comprehensive in terms of what you covered. It goes not just in terms of the laws relating to prior to pandemics, but during pandemics. And in my view, one of the most important sections also is how you refer to the role of non-state actors, which I think is going to come up in our discussion. So maybe you can also give us an overview of the broad range of areas that the principles covers. Thank you.
Absolutely. Thanks, Professor Mendez. Yes, so the Syracuse principles, the principles and guidelines on human rights and public health emergencies span several sections. So they have overarching human rights principles and obligations that are at operation throughout the life cycle of a public health emergency, if you will, from the prevention side of things to the preparedness aspect to the response, and of course extraterritorial human rights obligations as well that are sort of overarching, if you will, and operating at all times. But in addition to that, and I think this is one of the bigger contributions of the principles, is that they look more closely to the linkages between prevention, preparedness, and response, and specifically recognize this notion that I think we've talked about a little bit since the morning, that if a response to an emergency is to be the least, the response that interferes the least with our rights and with our rights and freedoms, it must be a response that has been thought through well in advance, right? That requires resources to have been invested well in advance in society to make sure that, for instance, the most marginalized are already taken care of, not just thought about suddenly at the moment of crisis, that is a group that we need to provide for now, or that they're being especially hit hard by the emergency. But I'm also going to hand it over to my colleagues as well to further develop that, because I think in particular, Tim might have some specific views on non-state actors.
Thanks very much. So the next panelist will be, I hope, appear on the screen. And it's a colleague from the ICJ Geneva, Tim Fish-Hodson. Just to give you his background, he is a legal advisor at the International Commission of Jurists in Geneva. He's responsible for designing and implementing ICJ's work around economic, social, and cultural rights in Africa, and assists with ICJ's global work on ESG rights. Before joining the ICJ, he worked as a senior researcher at the Socioeconomic Rights Institute. He also worked as a legal researcher at Section 27 and as a law clerk for Justice Zakaria Yacoub at the Constitutional Court of South Africa. Tim has published various opinion pieces, book chapters, research reports, submissions to state and institutions, and peer-reviewed journal articles. Tim, you can appear on the screen if you can. Because we may face the same problem with the next speaker, Luciano Bottini Filho, I suggest we go to a person who's in the room, who was the final speaker, but Safura Abdul Karim will be the next speaker. She's a public health lawyer whose research has focused on improving health law through the law. As a practicing lawyer and legal researcher, her policy impact ranges from advising the South African National Department of Health on food labeling to her contributions in addressing COVID-19 vaccine inequity in labeling to her contributions in Africa. As a Glide Fellow at the Berman Institute, she's interested in progress.
Tim, can you hear me?
Yeah, I can. There's just a bit of an echo there, but I can hear you now.
Tim, why don't you
I heard you say, why don't you? And then I heard nothing else. I'm going to guess that you said, why don't you go ahead? Okay, I'll try. I'm sorry that you can't see me. Just one correction. I mean, I work for the ICJ Global, but I'm actually in Johannesburg, South Africa. So that puts me at about 10 p.m. So apologies if things are less coherent than Regine managed to say. And also, I can tell you that video makes us look a lot more intelligent than we are. So that's a great start. I would like to say something about the non-state actors issue. I think that one of the major weaknesses of the response to the pandemic, and then one of the major issues to the pandemic accord as it currently stands, is the failure to actually even accommodate existing human rights law norms as meager as they are, to try and control private actors from doing harm in the face of a public health emergency. And so it's not really that the issue was just limited to pharmaceutical companies. All around the world, there were problems with responses and unavailability of healthcare services where services were being rationed out and split inequitably between public and private systems. And governments were needing resources to be able to treat people for COVID-19, but not capable of doing so because resources were held in the private sector. And so the principles really try and address this on two counts. And the one is to make it extremely clear that in the face of an emergency, that government must regulate and take steps to regulate and monitor, but also that the government can try and draw on resources from within the private sector in order to respond to public health emergencies. And then the second thing is that there's articulation and a development of what comes from the Ruggie principles on business and human rights, which is the duty to respect, which lies directly on the private entities and has to be fulfilled by the private entities. But this is developed, and I think it was an exciting discussion and development into acknowledging that actually sometimes private entities in a public health emergency might have positive obligations. They might have duties to fulfill rights. And I think that we saw all around the world news stories about ambulances, private ambulances not picking people up, private hospitals not allowing people access, private entities who had control of oxygen supply not sharing it. And so I think that this is like one of the very big things that the principles embody. I'll stop there for now. I just want to add one more thing about the Syracuse Principles. I think that the Syracuse Principles, the great victory and the enduring victory in the Syracuse Principles is the standards that any of us will know all around the world if we're constitutional lawyers or have worked in constitutional law, of necessity, proportionality, and legality for measures taken in the context of emergencies. And I think that the fact that many people apply those principles and they appear in many constitutions, but people don't even know that it has its genesis in the Syracuse Principles, is actually a sign of how effective they've been. And what we can really hope with these public health emergency principles is not that people know them off by heart or study them in every detail and in every provision, but there's key principles that exist in here that become so obvious to members of the WHO, to states, to human rights lawyers, that it's almost unthinkable to not having them included in the way that we respond to public health emergencies.
Hi everyone. Thank you, Virgin, for inviting me to this event. I cannot hear you from here, so I assume I'm allowed to speak now. But please interrupt me if I'm speaking out of turn. Yeah, I was really privileged to be part of this consultation. Very much working on the efforts to involve people from the global south. That's something that was quite unique in terms of consensus building, in terms of expert consensus, human rights principles. Yeah, I think the effort that was put into engaging people in the global south was quite extraordinary. Yeah, it was not ideal, and I confess that when I start being involved with this drafting process, I was a bit skeptical about how much we could engage with the global south, and I still question myself, what's the best approach, and there's a lot that can be learned with this experience in terms of how we access to people in the global south, and how we build human rights standards that actually are meaningful and participatory. Yeah, and the questions and the way we arrived to this at this discussion, trying to refine and elaborate what are the international human rights standards in terms of public health emergency, that comes in a very critical moment for global health, where the whole epistemic, the whole power relations in terms of knowledge users, populations in the global south, and experts in the global north are being questioned, are being challenged, and so we could not undertake this this project without making a serious effort to listen to the people in the global south. And I was glad that I engaged with some consultations in Latin America. After that, we had another meeting with other consultants that will cover different regions of the world in Nairobi, and this input was very valuable to this process. Yeah, I understand that this is that there are limitations to that, and we should continue to identify mechanisms to influence discussions in the global south in a way that actually is supportive, and there is a knowledge exchange, there's a co-production of meaning, yeah, in terms of human rights standards. And I'm hoping now that as those principles have been launched, we can continue these efforts to refine and criticize the limits of international human rights law, and find ways to reproduce the standards, yeah, that are suitable to local realities. So I'll leave it here, and yeah, I wish I was part of these conversations in person, but unfortunately I'm here in the UK, and I could not be part of the panel in person.
And we do, as some of you may know, have one of the most progressive constitutions in the world that contains both political rights, civil rights and liberties, as well as socioeconomic rights that are justiciable. And so when the state of disaster was declared, there was immediately two challenges that were launched, challenging the constitutionality of the state of disaster. The first one was launched in our constitutional court and was summarily dismissed. It alleged that the reason that the COVID-19 response shouldn't be as vigorous and rigorous as it was because Black people can't get COVID because of the nature of their skin, which of course is nonsense. But the second challenge is more interesting because it was a gentleman who understood that there was a need to have a rigorous lockdown and a need to have restrictive measures, but wanted to travel to another province because he wanted to attend his father's funeral. And the court said, unfortunately, there's nothing I can do. The government's decided to take these public health measures. And I think that's the kind of response that people today have been really concerned about. The idea that public health prevails and there's no such thing as human rights. Then there was a turning point in the jurisprudence of South Africa that happened when members of our defense force who had been called in to implement our lockdown measures assaulted a man who was violating the lockdown. And they assaulted him so badly that he died. And this was the first time that a South African court decided to really interrogate the lockdown measures. And the central reason that the court gave for holding and declaring this conduct unconstitutional was that it violated the right to life. And this was really where I think we began to see that there was a recognition of human rights, but the sense was that human rights were not compatible with a public health response, that public health responses were coercive, and that in order to protect human rights, you needed to curtail a public health response. So this all happened in the space of a couple of weeks. And then all of a sudden, something really interesting happened, which is the courts began to recognize that public health responses, especially a COVID-19 response, actually fulfill certain human rights obligations. The government needs to take certain kinds of action to fulfill constitutional obligations and protect human rights. And so we saw what actually became to be the defining feature of South Africa's jurisprudence on COVID-19 and human rights, which is that human rights are things that individuals have, and they are things that collective bodies of people have, that they are things that are held by communities. And so while individual rights may be limited by, for example, stay-at-home orders, those same orders operate to protect the public's right to health or the public's right to life, because you can't identify who's going to get COVID and who isn't going to get COVID because of a stay-at-home order. And so I think this provides a way for us to begin to understand what the future of a human rights response might be in a public health emergency, with the recognition that governments should ideally observe their human rights obligations as outlined in the Syracuse principles, as outlined in the new principles from Geneva, but simultaneously, they cannot adopt non-interventionist stances. They cannot take the approach that no public health response is needed, that there is some obligation on them to adopt some measures to protect the public's health. And that's not just a public health imperative, it's a human rights imperative. And I think that's really something that going forward should be carried and implemented at an international level. The idea that human rights and public health are deeply compatible, not just in the Jonathan Mann sense of a good public health response respects human rights, but that there is in fact a human rights obligation on governments to protect the public health. So those are my interventions for now, but I was hoping we could have a richer conversation about it.
So before we go to the floor, I do want to ask both Rujan and Safura, and hopefully, actually, we'll see if this is going to work. Actually, Rujan is going to sort of email some of these questions to the two in wherever they are. One of the questions, as somebody who's actually worked a lot with corporations around the world, I helped develop the Global Compact. I actually drafted the human rights principles, which then went on to the UN guiding principles on human rights. The one thing I have learned from that is that, and again, Professor Meyer, is one area I disagree with you, is the vast majority of corporations who I have dealt with around the world do not regard themselves as direct duties of international law, which is a huge problem. And ultimately, this is one of the fundamental challenges that I think your principals will have to deal with, because they do not regard any of that as being directed to them. One of the ways in which I suggest that you think about how you further develop it is take a leaf out of what is now happening in Europe, where they've decided Ruggie's guiding principles are not enough because they are just soft law and they don't have to be actually implemented. And now France, Germany, Netherlands are going beyond that to harder laws and introducing really hard laws of the duty of diligence, for example, which could include hard penalties. So one of the things I'm going to ask you, and maybe you can pass on this question to Luciano and Tim, is how do we take, especially with the non-state actors part of the principles, and try and drive it down into something which is actually going to work in real life? I don't know whether any of you want to deal with that.
All I'd like to offer is a criticism, is a criticism of the confining non-state actors' obligations to the protect component, which is in the context of a high-income country like the US, Canada, or even in Europe. It is true that to some extent vaccine inequity was driven by a government's failure to regulate these actors. But to contrast that to the South African example, or even the rest of Africa, the government's inability to deliver vaccines wasn't a result of a failure to regulate. It was down to private corporations failing to make their technologies available. Governments were in a position where they could not protect, fulfill, or respect their citizens' rights. And I think until we begin to see corporations who often are more powerful than these governments, who often have turnovers that exceed the GDPs of these countries several-fold, until we begin to recognize that they themselves are fulfilling roles that require regulation, that require obligations to be placed on them, we will not see fulfillment of human rights in low and middle income countries. That's my view.
A couple of folks in the room as well who have drafted the principles and might have thoughts on this too. So Ben, Alicia, or Lisa, do you have any specific thoughts on question that Errol posed, which is specifically around non-state actors and hardening it into legally binding obligations for non-state actors, in particular what we're seeing in Europe, but also I think Latin America, where the Inter-American human rights system has come in on this as well.
Hi, can I jump in? Can you hear me?
Is this okay? So I guess a couple of reactions to previous comments. One is, Sophia, you're absolutely right. It wasn't that the government wasn't regulating private, I mean, so that's the kind of the point of extraterritorial obligations, in that the government of Canada, for example, or the government of the United States or the government of Germany has an obligation to exercise control over a multinational corporation that is headquartered, over which it has effective control because it's headquartered in that country or otherwise. And the effects are transboundary effects. So the way the principles are drafted do take account of that imbalance, I think. This is a reasonably nascent area of international law. I actually would not concur with Ben in that the IMF and the World Bank absolutely don't think they have direct human rights obligations, even though they're international institutions. And that's one of the problems that we most face. But I do think on the extraterritorial issue, the principles do get us a step in the right direction. What were the other questions from Professor Mendes?
In many of the other areas where business, human rights, corruption, unless you have governments, and European governments are starting to impose that extraterritorial. Unfortunately, the United States, after the Kiobel decision, has eradicated that. So the courts are no longer willing to issue extraterritorial impacts for the US. And Canada hasn't begun. Our first law is actually going to become effective on January the 1st, just to have companies reporting on what they do in the supply chain. So we are so far behind in terms of this area that I think it's time for civil society and others to point out exactly what the question I asked you. We have to start imposing the rule of law from the bottom up. Don't expect a lot from the top down.
I completely agree with that. I do think there have been some interesting cases in Canada on mining, which was mentioned earlier, where basically slave labor was being used in a mine in Africa, and a court in Canada saw that the government of Canada had effective control over that, and it violated customary international laws.
Yeah, I was the co-counsel in that case, and guess what? It was a split decision. And with the change, because Rosie Abella, who was the one who managed to flip it over to the majority, she's gone. I worry about what's going to happen to that particular case in the future.
Go ahead.
Professor Mendes, I'm fascinated to hear about your foundational work in this area. So I'm wondering, it feels like we're in an evolutionary moment towards the development of legal responsibilities, some form of human rights responsibilities for business entities. I know you probably are more engaged in this than I, that there's a business and human rights treaty information right now, another human rights treaty that will join that I don't know that it goes too much beyond like the ruggy duty to protect, but it is going to be a binding treaty. So it feels like we're in an evolutionary moment. I'd like to think inexorably towards that. But I feel like maybe the other piece that comes out of the pandemic is, and certainly for me, you know, having been in Canada and viewing kind of the debates that were happening in the US, where people felt so outraged at the imposition, what they saw as a violent imposition, restriction of their rights by asking them to wear masks, by asking them to vaccinate, and voicing that outrage in the language of human rights, voicing it in the language of, you know, our charter rights are inviolable and they're being violated. So, and which was a fascinating, you know, from a human rights perspective, was a fascinating piece. I feel like the piece that surely comes out of that piece is, if we consider human rights as individuals, as entitlement based alone, aren't we missing out on a fundamental other part of it, that we as individuals have responsibilities, if not to our government, but certainly to each other? You know, so I feel like there's a very nascent non-state responsibility piece in human rights and in international law that I'd hope this moment provokes into something that ultimately, you know, kind of catches the big fish, but also implicates us as, you know, aren't we ultimately, what else does human rights mean if it's not vested in us in a real and fundamental way, and not just as the recipients of, you know, what governments decide to give us, but as something else, something more active.
Thank you for your question. I think it's a really important question. Just to answer your question in terms of my journey, I'm actually writing an article called "From Hope to Despair and Back to the Possibility of a Prayer." When I started in the 1990s working with John Ruggie on the Global Compact, the promise was that those soft laws would eventually turn into hard laws. Well, despair happened when John Ruggie took over, and he essentially basically did the guiding principles, where he was adamant that it would not impose direct duties on corporations. And at that spot, I split with him completely and then moved towards arguing for the harder laws, especially in Europe. And it's Europe which has shown that it is possible to go through that journey. In terms of the binding treaty that's being negotiated, it doesn't stand a chance in hell. The EU, the US, and others have said they will kill it the moment it actually goes further. But because of all that, I think these guiding principles that Rujan and your fellow collaborators have done is incredibly important, because take a lesson from what happened from the Global Compact to now. There is a case going on in France where there is a criminal prosecution against a Canadian cement company for being engaged in torture and possible murder because of their complicity with ISIS. That is amazing. To go all the way from 1990s, where Kofi Annan thought that the soft law would be the answer to that, where a court in France is potentially imposing criminal negligence, criminal potential liabilities on one of Canada's most powerful corporations. My hope is that your principles can have that journey, but it does require from the bottom up, because as I said, what you face from the top down in my question to Professor Ammon is that be prepared with mass hypocrisy, but don't ever give up, because there's always that attitude where you can move from the bottom up. It would take many years, maybe a decade, maybe 2 decades, maybe more, but don't ever give up.
Thank you. I think that this is also very much a message for the students in the room who've asked a lot of questions about the existential nature of the international system. So I'm looking at them too, and they've braved along. I just have to say they've been wonderful. They've been braving this whole day in the middle of exams to listen to this. So that's also something that gives me a lot of hope, and just it's very fruitful when students are in the room as well. Thank you.
Thank you. We have some time still.
So I think one of the questions that we grappled with in developing the principles was the question of what comes next. How do we make these real? How do we give them the staying power that the Syracuse principles have had before them, that the Ruggie principles have had, where they are taken on by courts, they're used in academic scholarship, they're used in civil society advocacy, they're used in international organizations. And I think at the end of the day, these things develop momentum because they are taken up by advocates first. And we saw that with the Syracuse principles, where the Syracuse principles became a rallying cry for civil society before they were taken up by international organizations. Is there anything that's stopping these principles right now from being taken up by advocates, by academics? And I wanted to get the panel's thoughts on how we can think about spinning these out, disseminating them throughout the world, and making sure that people outside of academic circles have their hands on them.
Fact that there isn't a pending public health emergency, which would have provided great impetus and for advocacy around these. But at the same time, I think it's worth thinking about their application even outside public health emergencies. So I was thinking specifically when I was reading through them about sort of rising tide of anti-homosexuality legislation in Africa, and how some of the principles arguably could be imported into those kinds of litigation and taken up by those kinds of advocacy groups. Because in many ways, yes, it's not a public health emergency in an acute sense, it's not COVID, but HIV remains a scourge in our world. And I think that this sort of backlash of anti-homosexuality legislation is a form of an emergency. And so I think looking for entry points outside of an acute emergency to build some recognition, adoption, and operationalization of the principles might be a useful idea.
Yeah, thanks, Ben, for the question, and totally agree with you, Sephora. And I think that one of the challenges with drafting the principles was that it engages with public health, and as a result, can get a bit technical, a bit into the territory of science and scientific knowledge. And for that reason, I think as a group, we both felt the need to be a little bit more humble about what we put into the principles, but also left the room for a tremendous respect for science and the evolving nature of scientific knowledge to enable us to better our responses to public health emergencies, which then would be a better public health response with rights as at its center. And so the challenge with the principles is not so much just to have them out there for the human rights lawyers to go and champion them in their own forums, but of course, to have them make sense to health workers, to have them make sense to professionals, to even community workers. So it needs like a huge socialization push, which comes not just from the text of the principles themselves, but advocacy toolkits and everything that comes after that, which we've seen with other principles in the past. So for instance, the Yogyakarta principles, which aim to bridge the divide between the gap that exists in international human rights law with respect to LGBTQ rights. They have done a really good job of establishing a forum for additional toolkits. So has, for instance, the Maastricht guidelines as well. So we have to continue to develop it and kind of give it a life of its own, and also to invite others to develop and improve upon it, the principles.
I'd like to give you a very different, very practical answer. I consider myself as much a practitioner as an academic. One of the things which I have noticed gets attention and gets soft law becoming more harder law is to focus on the most compelling situations which shock the conscience of people. And let me give you two examples, one domestic and one international. One of the things that should shock the conscience of people domestically was at the height of the COVID in Canada, was the fact that there was no mandatory sick leave by the federal government, and it was only some provinces which gave it, which meant that the people who suffered the most in the COVID were the ones who had to go to work without having paid leave, which includes, and I know there's nurses in the room, the nurses who actually were trying to save people, they had to get sick even while they were trying to heal and get people to recover. They themselves were getting sick. That should have shocked the conscience of people across Canada and said, there is a fundamental human rights issue in this case. It never was done. And I was wondering, why the hell? I wish I'd managed to sort of stoke people to come up with a major class action suit against Ontario in particular, who was very reluctant in doing anything in that area. So that's a domestic one. The international one, which I would have loved to have a country like India and others think about a massive attack. One of the videos you had the fires which were burning people. There was so much, they didn't have enough room in the cemetery. So there were tens of thousands of people being burned at these pyres. What's stunning about that, just even a few miles away is an institute which could actually produce vaccines for the whole world. It's the Serum Institute in India. Why didn't they do it? Why? Because the TRIPS waiver meant nothing for all the reasons that were mentioned throughout today. And they knew it. All the governments who basically promoted that, including our own government, which was probably one of the most hypocritical, because they said that in public that they were supporting it. In private, I know, because I got people in that area who were basically saying, please do not allow this to go ahead. So even our own government was acting hypocritically. At the same time, at the international level, no one was pointing out that if they had done a proper TRIPS waiver and given the full ability, the goodwill and the IP ability for the Serum Institute, it alone could have at least helped South Africa and been able to assist with the vaccine production there. So again, there was no absolute outcry of that, which should have shocked the conscience of the world again. So my suggestion to you is focus on things that shock the conscience in all the areas of your side and work on it. And never, ever stop doing that, because that's the way you go from soft law to hard law. Sorry, I shouldn't have gone that far. Yeah.
If there's any other questions in the room, otherwise we can take a break. Oh, yeah, please.
Hi, thank you for everything, and thank you for today. I'm Jennifer O'Neill. I'm an assistant professor in the School of Rehabilitation Sciences. So I'm coming from outside a little bit here of the box. But I thought that the question that was just answered regarding to where do we go, from what's the next step essentially with the principles. And I'm just wondering, have you considered including other people outside, so allied health, rehab professionals, nursing, into the development of the guideline and the principles, and B, like you said, to make sure that the principles are accessible to everyone to implement. So thinking about implementation, where do we go from there in terms of, again, implicating some of the healthcare professionals and rehab because we know rehab is important too.
Yeah, rehab is very important. Thank you so much, Jennifer, for that question. And it's wonderful to meet another colleague in the university. The principles were developed, and this was actually the focus of Professor Bottini Filio's presentation, but unfortunately it wasn't working properly from the tech side. The principles were actually developed over a course of 3 years, and the process of developing them had sort of a bimodal structure. So there was a group of experts who were invited by the International Commission of Jurists and the Global Health Law Consortium to take part in the initial drafting and the reviews of subsequent revisions of it. And they've all endorsed the principles, so their names are at the back of the document. I realized, oh, do you have a copy of them, Listen? You found it. Okay, great. I just realized I hadn't shared a link. So, and the other aspect of it was that following that sort of that top level drafting part of it, which involved a lot of lawyers, the second level of it was the regional consultations. And so this involved going deliberately with the principles to communities in all 6 WHO regions. Now, we're not going to overpromise and say it was a very representative, right? It was representative far more than what we've seen in these types of drafting efforts in the past, and even more so than I think some of the international legal instruments that we're talking about right now, in terms of the perspectives that it invited from people who are not necessarily in the room where things happen, right? In the room where the negotiation happens. It involved perspectives from health professionals. I'm not sure specifically how many were allied health professionals, but there were definitely, there was a drive towards reaching out to frontline workers, community workers, physicians, and of course, lawyers as well. So we tried to scope this out among the regions. And so they informed through their input and lived experience the next draft of the principles, after which we again met in Geneva. And on the basis of their input, we revised the final draft. So it was sort of an iterative process. But thank you so much for that question. In terms of implementation, I think, so this is what I alluded to when I said, I hope others build on it, because I think that it ultimately now becomes a product. It's public, like there's nothing, nobody holds intellectual property or copyright over this. Obviously that's going to go into a journal that's open access. But what I mean is that nobody owns this per se. Everybody's welcome to take it and use it the way they want to use it, and the way that it's useful to their work, and the way it isn't, not to use it in that sense. The idea is for it to give some sort of normative scaffolding to the arguments that we've seen that we need to make in responses and in prevention and in preparedness in terms of public health emergencies, which are far more holistic than what we've seen in WHO's sphere right now. Thank you.
Any other questions?